Hi, this is Suman Das Vidya-mitra, Assistant Professor of Law at National Law University, Odisha, Cuttack, and today I am here to discuss a module on the law relating to dowry in India as part of your course in Substantive Criminal Law. Before we begin with the details of the topic, let me first introduce you to the idea of dowry. Of the many social problems that we face in India, the problem of dowry is probably the most unique. It is suggested that the roots of dowry in India date back to the later Vedic age of the Indian society, where the position of women had just started degenerating. Ever since, we are acquainted with the concept of dowry in India across various communities of the country. No matter how old the roots of this problem are, its impact remains the same even today, and maybe it has even got worse with time. The problem of dowry is not specific to any particular religion in India or to any particular community in the country. It is a problem which has affected all religions, regions and communities in some measure or the other. Now, as we go ahead, I think it will be pertinent on my part to lay down the objectives of this module. The objectives of this module are threefold. Firstly, to introduce students to the problem and concept of dowry, to inform them of the laws in India relating to dowry, and to discuss important case studies to trace judicial trends in this area. Now, to begin with, I would like to discuss with you the Dowry Prohibition Act of 1961, in which section 2(1) of the act defines the term dowry, and when read together with the explanations, it provides the following elements in the concept of dowry. First and foremost, the subject matter of dowry may be any property or valuable security. Such property or valuable security may be given or agreed to be given directly or indirectly by either party to the marriage or by parents of either party to the marriage. The transaction of property or valuable security must be in connection with the marriage and may be given at the time of marriage or before the time of marriage or after the marriage. Dower or mahar, which is a very important concept in Muslim law, at the time of nikah, which is given as a form of gift, is excluded from the denotation of the term dowry under the Dowry Prohibition Act 1961. Gifts or presents which are made to either party at the time of marriage in the form of jewelry, clothes, cash or other articles are also excluded from the purview of dowry under the legislation. Now, as we begin to understand the various elements of dowry, it will be pertinent for us to also look into the concept of valuable security or movable property. Now, when we say valuable security, what exactly is connoted by the term? Section 30 of the Indian Penal Code discusses the concept of valuable security, and in the IPC, valuable security is defined as any document which has the capacity of creating rights, extinguishing rights or altering or amending rights. Now, when we talk about property, because the definition of dowry, as we remember, includes in its connotation that it involves the exchange of valuable security or property. Such property may be movable in nature or it may also be immovable property for that matter. When we say movable property, we refer to things like cash, ornaments or artifacts or other such valuable things. But when we say immovable property, we refer to property which may be in the form of a land or a house, etc. So, all these things can come within the purview of dowry if they have been made as a consequence of an exchange at the time of marriage, and they have been in connection with the marriage, they have been either given or agreed to be given by either party to the marriage or by representatives of the party to the marriage. Now, Dowry Prohibition Act 1961 penalizes not only the taking of dowry, but it is important to notice that under section 3 of the Act, both the process of giving and taking of dowry has been penalized. Under section 4, the Act also states that any agreement for the giving and taking of dowry will be treated as void. Section 8 of the Act provides that offences under this Act will be non-cognizable, bailable and non-compoundable. A well-known case in this connection is the case of State of Andhra Pradesh versus Raj Gopal Asava and another. Now, in this case, the husband, brother-in-law and mother-in-law of the deceased were put on trial for suicidal death of the bride. In the trial court, there was sufficient evidence to show that demands for dowry had been made by the brother-in-law and the mother-in-law, whereas the husband's participation was put forth as only passive. Although all of them were held guilty under section 304B at the trial court, the High Court acquitted the three of them on the ground that there was no evidence to show that an agreement had been entered into for the payment of dowry, and therefore, since there was no agreement, the High Court had ruled that this cannot be a case of dowry. Now, if there is no dowry, the linkage between dowry and death has not been established. Obviously, it cannot also be a case of dowry death. Further, it was also held that demands made after the marriage would not qualify as dowry. On appeal, however, the Supreme Court held that the demand for dowry does not presuppose an agreement to the effect. This case was a landmark judgment of the Supreme Court in the field of dowry for various reasons. First of all, the issue of whether an agreement has to be formed for the purpose of defining the concept of dowry was a necessary proposition. So, here the Supreme Court ruled that an agreement is not a necessary portion or a necessary part of the concept of dowry. There may or may not have been an agreement to the effect, and one need not look or fish out for evidence in connection with this. And even in the absence of an agreement, a question of dowry may be answered in the affirmative. The court also observed that the purpose of amending section 4 of the Dowry Prohibition Act of 1961 was also to reiterate the fact that demand for dowry may be either direct or indirect, it may be active or it may be passive, and all such forms of demands for dowry have been covered under the relevant section of the Dowry Prohibition Act 1961. The interpretation of section 2 must also be made in the light of circumstances of every case. So, whether in an individual case an indirect demand for dowry or a direct demand for dowry can qualify as a dowry or as a concept of dowry within the purview of Dowry Prohibition Act of 1961 is a necessary factor for us to understand. Therefore, the claim of the respondents that a dowry can be said to have been demanded only when there is an agreement to the effect was not justified according to the Supreme Court and was also not held to be legitimate, which is also why such an interpretation was reversed by the Supreme Court. So, the High Court's consideration of a judgment which had been delivered as a situation of as not a situation of dowry death, because no question of dowry was there in the picture due to lack of an agreement, was reversed entirely by the Supreme Court in this case. Likewise, in the case of the Public Prosecutor, High Court of Andhra Pradesh versus Nesse Jilara Sri Ramulu, two cases were referred by a division bench of the High Court of Andhra Pradesh for consideration by a full bench. The two cases referred were Ayala Rambabu versus State of Andhra Pradesh and Nunna Venkateswaralu versus State of Andhra Pradesh. The objective was to verify whether the points that were laid down in these cases were good in law. Sections 2, 3 and 4 of the Dowry Prohibition Act were primarily looked into. The High Court referred to Nunna Venkateswaralu's case, where the single judge held that the definition of dowry contemplates that there must be an agreement either before, after or at the time of marriage for exchange of valuable security or property, and unless such agreement has been proved to be on record, a person cannot be held guilty for an exchange of dowry under Dowry Prohibition Act of 1961. The single judge pronounced the judgment based on the decision of the division bench in the case of Ayala Rambabu. For identifying whether the cases were good in law or not, the High Court referred to the case of Pawan Kumar versus State of Haryana, in which the Supreme Court had held that the intention of Dowry Prohibition Act 1961 is to penalize any demand for dowry irrespective of whether the demand was direct or indirect and whether or not there was an agreement to the effect. Further, there is also a discussion of this case of Prem Singh versus State of Haryana, in which the Supreme Court had held that additional demand for dowry can also be covered within the meaning of dowry in section 2 of the Dowry Prohibition Act. The words "at any time after the marriage" may appear to be of an unlimited span of time, but the court held that the more significant words are "in connection with the marriage of the parties." Now, at this juncture, it will be relevant for us to look into the details of and the specifics of the words "at any point of time after marriage," which has been discussed in the case of Prem Singh versus State of Haryana. Now, when we say or look into the Dowry Prohibition Act 1961, we try to discuss the concept "at any point of time," the span of time which seems to have been covered looks very large in its scope and very unlimited in its scope. But the idea is whether we can keep on punishing an individual for demanding dowry for an entire lifespan of a woman concerned, or is there any limitation in terms of the duration, for instance, maybe like for instance when we talk of dowry death under section 304B of the Indian Penal Code, the span of 7 years is relevant. So, any death in connection with dowry is presumed to be a dowry death if the death happens within the span of 7 years. But the terms "at any point of time after marriage," which have been captured in the Dowry Prohibition Act of 1961, need to be looked into with a little bit of analysis here. So, here we have to read these terms in connection with the words "in connection with marriage." So, when we say that the demand for dowry has been there, what is more relevant is, was the demand for valuable security or property made in connection with marriage? Now, at what point of time after marriage it was made is not as much a factor which requires discussion, as it is important for us to find out whether such marriage such demand was made in connection with the marriage between the two parties. Now, after the Dowry Prohibition Act, I think it will be pertinent for us to also look into the provisions made under section 304B of the Indian Penal Code, which is again a major piece of law which was introduced by way of an amendment after the Dowry Prohibition Act was passed. The amendment was made in the Indian Penal Code to cater to the needs of those women by punishing the perpetrators of a crime under 304B against such women. So, there are primarily, as the concept of 304B, the term dowry death would itself connote, there are primarily two important figures here that we need to note. First, it must be a case of dowry, and of course, it must have resulted in the death of the woman. So, the provisions under this section are attracted only when the woman has died as a consequence of a demand for dowry. So, the ingredients under this section can be captured as, first and foremost, the death of a woman must have ensued within 7 years of her marriage. Such death may have been caused by burns, bodily injury, or under circumstances which are not otherwise normal. The woman should have been subjected to cruelty soon before her death. Such cruelty must be meted out by the husband or any of his relatives in connection with a demand for dowry. Now, an explanation of these ingredients is pertinent at this point. So, the first requirement says that a woman must have died within 7 years of her marriage. Such death should be abnormal, or it should not be under natural circumstances or normal circumstances. So, what is exactly connoted by the term normal circumstances or natural circumstances? So, for instance, a woman who dies out of sickness for a prolonged period of time, or who dies because of some sort of injury that she has received, or some kind of ailment that she has been going through for a long period of time, they are all covered within natural processes of death. Now, when we say abnormal situations or unnatural conditions, it has a bit of a history which I think will be important for us to discuss right here. Now, during 1960s and in fact before the 1960s, before the Dowry Prohibition Act also came into the picture, and sometime also after the DP Act came into the picture, we had the phenomenon which was tagged as bride burning in India. Now, bride burning is a concept with which all Indians are familiar, wherein the woman or the bride may be a newly married woman, or a woman who had been married for a couple of years of her marriage. Many of them, they faced a death in the kitchen. Now, the stove accidents or the accidents because of bursting of a gas cylinder was so common in Indian matrimonial homes that they started gathering attention as to why such things were happening. So, it was very common at that point of time to have women dying in the kitchen while they were cooking. Probably the kitchen was considered to be a perfect place for committing the murder of a woman who had not really brought the amount of dowry that was expected by her in-laws. So, the woman formed the perfect victim, the kitchen formed the perfect scene for killing the woman, because women were generally associated with the kitchen. And of course, the perpetrators were the husband, the relatives of the husband, and the number of such crimes started increasing at a phenomenal rate over a period of time in India. Now, to counter such measures, we had brought into picture the section 304B, which was thought to address the problem pertaining to dowry death in India. So, which is why the terms here become relevant, the term killing a woman or the death of a woman under circumstances which are otherwise not normal. So, the death also may be caused by burns or bodily injuries, or under any such circumstance which does not appear to be normal. The woman, again, the third ingredient that I had mentioned was that she should have been subjected to cruelty soon before her death. What is the connotation of the term soon before? We will be discussing very soon in the later part of the lecture. And the last point is that such cruelty should be meted out by the husband or any of his relatives in connection with the demand for dowry. Now, the last two points are interrelated, so we would like to examine them or discuss them by referring to certain case laws by the High Court or the Supreme Court. So, let us first take a look at what constitutes or amounts to a situation of demand for dowry. So, what is the connotation of the term demand here, and how exactly do we satisfy that? Now, as I mentioned earlier while discussing the definition of dowry under the Dowry Prohibition Act of 1961, dowry refers to an exchange between two parties of a property or valuable security at the time of marriage, before the time of marriage, or after the time of marriage, and this exchange is always in connection with the marriage. So, in the case of K. Prema Rao and State of Andhra Pradesh versus Yadla Srinivas Rao and another, the question was raised as to what constitutes demand for dowry. So, when we say dowry and demand for dowry, what exactly is the nexus between the two terms? So, the court had in this case very astonishingly laid down that harassment for Sridhan does not amount to dowry. Now, in this particular situation, the victim had been given some amount of property as stridhan, or a property over which a woman has absolute ownership. The property was given to the woman by her father, and within a very short span of time after her marriage, a couple of months after her marriage, the husband kept on pestering with the woman to transfer the documents to his ownership, and the woman would not agree with it. This continued for a couple of years, after which she committed suicide out of frustration, because she couldn't tolerate the harassment that was meted out to her, both physical and emotional harassment. Surprisingly, the court held that this doesn't amount to a situation of dowry, because the stridhan property which we were referring to is not the subject matter of dowry. Now, one requires a critical mind to be able to criticize the outcome of this judgment. Why exactly stridhan property or harassment for stridhan property would not amount to dowry is a question for us to reflect upon. Then the term soon before her death has always attracted our attention. So, when we say soon before, what exactly is meant by it? Is there a specific time span which would qualify as soon before, or is there no time span, but we need to infer it from the circumstances of a given case? Now, I would like to bring to your notice the case of Keshav Chandra Pandey, where the accused had assaulted the woman, in this case the victim, with an iron rod. This is a case whose incidents were recorded in the year June 1989. So, the victim had been beaten with an iron rod, assaulted with an iron rod by her husband in June 1989. What follows is a very interesting set of facts. Now, after being attacked by the husband in June 1989, the woman thought that the marriage, in fact, it's not that she only thought about it, but the marriage was in shambles. So, after this, there was mediation by some elderly people in both the families, and the woman continued to stay in her house for about a year. And after which, one fine day, the husband leaves the woman in the house of her parents, and there were persistent demands for dowry, which has also been established in all the courts at all the levels. And the attack was also connected with the dowry demands. However, after leaving the woman in her parents' house, a fortnight after that, she returned to the husband's house, and 2 days after returning to the husband's house, she had committed suicide. So, the question in this case was, would this situation amount to a situation of dowry death? Is it a situation of dowry death, or is it just a situation of suicide by a woman? And interestingly, the court in this case had held that this is not a situation of dowry death, because the assault was made way back in 1989. So, while that assault may have been connected with a demand for dowry, there was nothing on record to show that there have been demands of dowry after the husband, after the mediation was done, and after the woman had returned to the husband's place. And the next question, which again the court very astonishingly posed, was, if at all she was the victim of dowry, why is it that she waited for 1 year or 1.5 years to commit suicide? The suicide wasn't immediate, and therefore it cannot be said to be a case of dowry. What perplexes many people who have read the case, and what comes to my mind even and may come to your mind, is, was there any situation other than dowry which could have been or which could have triggered the death of the woman, or the commission of suicide by the woman? If there was no other factor which could have triggered the death of the woman by suicide, then how is it that it's not a case of dowry death? Probably the prosecution wasn't well conducted, but the question remains a $1 million one till date. So, the term cruelty can be interpreted in the same way as it has been interpreted under section 498A, rather to the explanation given under section 498A. Now, at this point, let us then discuss another landmark case of Ram Badan Sharma versus State of Bihar. in which the court laid down that there is no exact time span which is specified for identifying what amounts to soon before the victim's death, but the link should be proximate and not remote. So, Keshav Chandra Pandey versus State again has been the same thing. It has reiterated, as we discussed in the last few minutes, that it has reiterated the point that soon before her death cannot be an elongated or prolonged period of time. In the case of Rajinder Amar Singh versus State of Haryana, it was laid down that the link between a demand for dowry and the death which follows must be established, because unless that link is established, the situation cannot amount to an offence under section 304B or an offence of dowry death. And then we have the case of Shanti versus State of Haryana, where the very important fact that section 304B and section 498A are not mutually exclusive was laid down by the court. So, when we say that the two sections are not mutually exclusive, it logically leads us to the conclusion that the term cruelty in section 304B can be interpreted in the same manner as under section 498A. Then another important thing which one must mention while discussing the concept of dowry death is that a simultaneous amendment was made in the Indian Evidence Act, wherein section 113B was inserted into the Indian Evidence Act along with the insertion of section 304B in the Indian Penal Code. The purpose of making the amendment in the Indian Evidence Act was to smoothen the trial of dowry deaths and to have a lesser burden on the prosecution to prove such a case. So, this talks about a presumption as to dowry death. So, which means that under the Indian Evidence Act, the court will presume that if a woman has died under abnormal circumstances within 7 years of marriage and there is evidence to prove that there was a demand for dowry in connection with the marriage and she was meted out cruelty because of demand for dowry, the court will presume that it is a situation of dowry death, and then the proceedings will take their shape accordingly. So, this is a variance from normal offences wherein the burden lies on the prosecution to establish a case beyond reasonable doubt. So, as to conclude, dowry death is a problem which is found uniquely in India, and the problem persists because of a social conditioning that women are inferior to men. And they are always perceived as inferior to men and are also considered to be economic burdens despite the multifarious contributions that they make in the matrimonial household. Despite their contributions to the affairs of the family, they are always considered to be a burden, which is where exactly the justification comes from the groom's side for a situation of dowry. Now, the Act, to summarize what we did in the last few minutes, the Act, the Dowry Prohibition Act of 1961, penalizes both the giving and taking of dowry. That is a point to be noted. The idea behind penalizing both the giving and taking of dowry is to ensure that there is no facilitation for giving or promoting the cause of dowry by few brides' sides. A demand for dowry may be either direct or indirect. Section 304B of the Indian Penal Code punishes dowry death. Along with Section 304B, Section 113B was introduced into the Indian Evidence Act via an amendment for the purpose of facilitating the smooth prosecution of cases relating to dowry death. For proving dowry death, the first thing that needs to be proved is the existence of a demand for dowry. That would be all. Thank you.